If someone named you as both the executor of their will and the successor trustee of their trust, would you actually know when you're acting in each role? Most people wouldn't, and that's because these two jobs are often happening side by side, even though they're governed by completely different rules. Today, I'm going to untangle that confusion and show you exactly where each role begins, where it ends, and why one estate can involve both at the same time. Hi, I'm Darlynn Morgan. I'm a trusted estate attorney, and for more than 25 years, I've helped hundreds of families navigate trust administration and probate. And I can tell you, this is one of the most common and most misunderstood questions that people have. In this video, I'll show you exactly what an executor does and what a successor trustee does. How to tell whether an estate needs probate, trust administration, or both. And the one mistake that causes the most confusion when someone is trying to settle a loved one's estate. But before we get into the differences, let me tell you about a client that I'll call John. John came to see me after his mother passed away. She had a trust, she had a will, she owned a home, a rental property, and several bank accounts. Like a lot of families, John assumed that everything would simply pass through the trust and probate wouldn't be necessary. But when we started reviewing Mom's assets, we discovered something important. Almost everything had been properly titled in her trust, except one, her home. A few years before she passed away, she refinanced the property. And during that process, the house was taken out of the trust, and after the refinance was complete, no one ever transferred it back into the trust. Unfortunately, I see that happen more often than you might think. And that one oversight changed everything. Now, John wasn't just acting as the successor trustee named in his mother's trust. He also had to serve as the executor under her will because the house had to go through probate before it could ultimately end up where the mother intended. So now, John was wearing two completely different hats at the same time. And that's exactly where so much confusion begins. People often interchange these roles or think executor and successor trustees are two different names for the same job. But they're not. They're two separate legal roles that operate in two very different systems. But sometimes, just like in John's case, they're both part of the same estate, and they end up running alongside each other until they finally meet at the end. So let's start by defining each role, because once you understand that foundation, the rest of this process becomes easier to understand. So what is a successor trustee? Let's start there, because that's usually the role that people expect to be serving in if their loved one created a trust. A successor trustee is simply the person named in the trust to step in when the original trustee can no longer serve. That might happen because the original trustee resigns, or it could happen because they become incapacitated, or most commonly because they passed away. One thing that surprises a lot of people is that your authority doesn't come from a judge. It comes directly from the trust itself. The trust document names you as the next trustee. So once the conditions in the trust have been met, usually after the death of the person who created the trust, you have the legal authority to begin acting on behalf of the trust. That means gathering assets, protecting them, paying legitimate debts and expenses, communicating with beneficiaries, filing any required tax returns, and eventually distributing those assets according to the terms of the trust. Notice I keep saying trust assets. That's important because as successor trustee, your authority only extends to assets that are actually owned by the trust. And that little detail is exactly what created John's problems. His mother's rental property? In the trust. Her bank accounts? In the trust. But her home wasn't. So even though he was the successor trustee, he couldn't simply transfer the house because legally it wasn't owned by the trust anymore. And that's where the executor enters the picture. So what is an executor? Let's talk about that. An executor is the person named in a will to handle the probate estate after someone dies. Unlike a successor trustee, an executor doesn't have authority the moment that the person passes away. In fact, this can surprise people. Just because you're named as the executor in the will doesn't mean you can immediately start acting. You have to be formally appointed by the probate court first. The court issues what's called letters testamentary, and that's the document that gives you the legal authority to act on behalf of the estate. Until that happens, banks generally won't talk to you. You can't sell property. You can't access probate assets simply because your name appears in the will. Once you're appointed, your job is to gather the probate assets, notify creditors, pay valid debts and taxes, and eventually distribute those assets according to the will or sometimes according to state intestacy laws if there isn't a valid will. So at this point, you might be thinking, if someone had a trust, why do we even need an executor? And that's a great question. And the answer is, sometimes you don't. If every asset was properly titled in the trust before the person died, there may be no probate at all. In that situation, the executor is named in the will, but there's really no job for them to do because there isn't a probate estate to administer. The successor trustee handles everything. But if there are assets that were left outside the trust, like John's mother's home, then probate may be necessary for those assets. And that's when the executor steps in. So whether you actually serve as executor doesn't depend on whether there's a will. Almost everyone has or should have a will. It depends on whether there are probate assets. That's the question that really matters. And that's where people can get confused because they focus on the documents when they should really be looking at how the assets are titled. So here's what it really comes down to. Whether you're acting as a successor trustee, an executor, or both depends on one thing: how the assets are titled. If an asset is owned by the trust, the successor trustee handles it. If an asset is owned by the individual, then it has to go through probate, and that's the executor's job. Sometimes it's one or the other, but other times, like in John's case, it's both. At the end of the probate, the house was transferred into the trust under the pour-over will, and from that point forward, John continued administering it as successor trustee. So here, John was wearing two completely different legal hats. And that's why it's easy for people to get confused. They're two different legal roles, and whether you're acting as one or the other depends on which asset you're handling and whether you're operating in the trust administration lane or the probate court lane. Now that you understand the difference between a successor trustee and an executor, one important question that often comes up is, what exactly does the trust tell me to do? And if you've ever looked at a trust document and felt completely overwhelmed by the legal language, don't worry. In my next video, I'll show you how to read a trust document, even if you don't have a law degree. So click here and I'll walk you through it step by step.